Good morning, Your Honors. Chad Lang from, may it please the Court, Chad Lang from Lang & White Colts on behalf of the appellant, Renee Spector, and I have with me Dale Schley, my associate, as well. I would like to reserve 3 minutes for rebuttal, Your Honors.
Okay, that 10 minutes is all yours, so at 3, since you've asked for it, the yellow light will go on, letting you know that of the 10, you have 3 left.
Okay, very well, thank you. This is an appeal of a final order denying proceeding supplementary against in-pled party Ellen Spector. The appellant in this case is Renee Spector. Renee Spector was married to Robert Spector. In 1996, she was divorced from Robert Spector and agreed in a marital settlement agreement for Robert Spector to pay her $5,000 per month in alimony. Since 1996, Robert Spector was willfully non-compliant with his support obligations. In 1999, a motion to enforce final judgment of dissolution was filed, and ultimately an order was entered establishing arrears at that time of $128,000. Thereafter, Robert Spector continued to be non-compliant and not pay his alimony obligation. In 1999, Robert Spector was married to the appellee in this case, Ellen Spector. 5 years later, he transferred his homestead property that he was living in on his own and thereafter with Ellen Spector to himself and the appellee Ellen Spector in this matter. Then, in 2011, a whole life insurance policy that he owned individually and that was self-perpetuating, he transferred to the appellee Ellen Spector without any consideration.
Mr. Lang, let me ask you this. The divorce final judgment references a $750,000 life insurance policy. And the husband transferred title to the Mass Mutual life insurance policy to him and the wife. I get that. Was that policy, Mass Mutual policy, was that the same policy that was referenced in the divorce final judgment?
It was not. The Robert Spector had multiple life insurance policies. He did have a separate, just regular life insurance policy that was held for purposes of Renee Spector, the appellant in this case, but the whole life policy, the Mass Mutual policy that he transferred was just an asset that he had that he improperly, in our position, fraudulently transferred to the appellee in this case.
Okay, so is there still an existing policy that he is holding and where the beneficiary is his former wife?
There's still an existing policy, but it's just a regular life insurance policy. It's not. It's not part of this proceeding.
Okay. As to the Mass Mutual life insurance policy, one of the sections that seems to come into play is Section 222.14. Florida statutes. We used to have statutes for all the judges up here, but we don't now. But I mean, I'm sure I'm taking up your time, but I know Judge Sickland's really liberal when I do that. But it says here that the cash surrender values of the life insurance policy, it really seems to protect it unless the insurance policy was affected for the benefit of such creditor. And so in this case where the wife this isn't the policy that was for the benefit of the wife, why doesn't Section 222.14 preclude that particular policy from being the subject of proceeding supplementary?
So interestingly, Your Honor, in 1997, in the case of Siegel versus Siegel, 700 Southern 2nd 14, Your Honor wrote the opinion in that case, obviously in this court. That case specifically addressed this issue. The narrow ruling that the trial court erred on is in our proceeding supplementary is what the trial court did is that they looked to, was this asset ever collectible under the contempt powers of the court? Because if it was never collectible, if it could never be levied upon, then it's not an asset that would be subject to a fraudulent transfer. And so the narrow ruling that the trial court did is they said the court has reviewed the memorandum of case law and find that both transfers, which includes the insurance policy, were not fraudulent as the assets were protected from creditors prior to the transfer. So what the trial court did, it was saying that under the contempt powers of the court, if we were just looking at that policy from Robert Spector, that it was not collectible. It was not subject to levy. Same thing with the homestead exception. Except in your case of Siegel v. Siegel, in your written opinion, and the cases that were before and after, the Gephardt case and the Partridge case, which are also in the 4th District, Your Honor specifically found in a Chapter 61 contempt proceeding, a trial court may properly look to a former spouse's individual retirement account to determine whether that spouse has the ability to pay a purge amount in a contempt order. Contrary to appellate's argument, the Section 222.21 Florida statutes exemption of an IRA account from all claims of creditors does not shield IRA assets from a court order to pay Chapter 61 support obligations. You go on to say
No, go ahead.
that in Bowen v. Bowen, the Supreme Court stated that in determining whether a contemptor possesses the ability to pay a purge amount, the trial court is not limited to the amount of cash immediately available to the contemptor, rather to look to all assets. Under Chapter 61 in Bowen, an IRA is not a safe haven where a former spouse can hoard assets, and goes on to talk about that the court has affirmed a trial court's order requiring a former spouse to sell a residence to meet alimony obligations, even though the home qualified as homestead exemptions under Article 10, Section 4 of the Florida Constitution.
But if we separate the homestead from the insurance policy, and I get that it says that about the homestead, Siegel talks about distribution of retirement plans. There's a specific section in Chapter 61. Is there a similar section about insurance policies in Chapter 61?
Well, what Siegel's talking about and what the Gephardt case goes into is in a contempt proceeding, the court could look to all assets. And the reason for that is in family law cases under Chapter 61, there's equitable distribution. In equitable distribution, the court divides equally all assets that are subject to the marital estate. So in the Gephardt case, in the Bowen case, in the Partridge case, they all give explanations of because the court in equitable distribution is allowed to look at that, when it comes to contempt, it's such a broad scope because they don't want to protect a husband or an obligor who's required to pay alimony or child support, to shield them by them hiding it in a whole life policy or any sort of asset that usually has an exemption under 222 or homestead or otherwise. The contempt powers of the court are so broad they could look to any asset.
Okay, so, but this isn't a contempt proceeding. In other words, this isn't a proceeding where the judge said, okay, you pay this amount within a certain amount of time or go to jail, which the judge could do. This is a chapter, a proceeding supplementary where you're asking the sheriff to levy against property. Does that make a difference?
It doesn't, because the way the court ruled is under the contempt powers of the court. It was never subject to levy. This is a proceeding supplementary because we couldn't do this in a contempt case. In a contempt case, the husband had already fraudulently transferred the assets to the wife. And actually, a case that was cited by the appellee in this case, which is Meyer v. Faust, 83 Southern 2nd, 847, which is a Florida Supreme Court case, 1955, actually discusses this issue and says you have to file a proceeding supplementary in order to attach an asset that has already been fraudulently transferred. The reason for that is because that asset is being held by a third party. Okay. You can't, in a contempt case, because that person is not an actual party, reverse that transfer because you need that person to be before the court who's holding the deed, who's holding an insurance policy, in order to affect the change. So in our case, the only mechanism to go after these policies would be to do the proceeding supplementary, to have the court reverse the transfer because they find the badges of fraud, which are all evident in this case from the record, and then force the sale of the property. The problem in this case is the trial court found, under the contempt powers of the court, they were never able to do that, and these assets were never subject to levy, even sitting in a contempt proceeding.
On that, the procedural question, there was an order from the court stating that the former wife has shown entitlement to proceeding supplementary, and later, for the reasons you just said, denying the, I guess, the petition for proceeding supplementary. What is it that you're asking us to do? Are we to remand to consider whether he should institute proceeding supplementary, or, I mean, because the order is somewhat confusing, the final order, where it simply states proceeding supplementary is denied.
Well, the order, it goes through.
It does go through those things.
The findings, and the court never got to whether the transfer was fraudulent and whether the badges of fraud were there, because the court found under the narrow issue and ignored the Fourth DCA case law for some reason.
So are you asking us that we remand so the court can make those findings?
Well, it's our position that in the record that it's clear that the badges of fraud are all there, that this was a fraudulent transfer, that there was nothing presented by the appellee to show that there was any consideration paid for this transfer, that there was ever any money put into the property after these transfers were made. To the contrary, what happened with the whole life policy was Robert Spector transferred it to the appellee, and then she liquidated it and put the monies into the house. So it's our position, based upon the record before you're able to make those determinations. If you were not able to do that, then yes, we would ask that it would be reversed to correct the error of law that's in the order, and then the court would make those findings as far as the fraud.
Well, didn't the trial court, though, find as a matter of law that this could not be, these transfers could not be fraudulent?
They found as a matter of law they could not be fraudulent because the court found that it was never an asset because it was never subject to levy. So at the time of the transfer, when the former husband owed it, and when the former husband owed money to the appellant in this case, that even if you were sitting in contempt proceeding at that time, that you were never able to levy on those assets, and ignored the law in the 4th District. So because at that time the trial court found that it wasn't subject to levy, they're saying that it can't be a fraudulent transfer.
And if I could just have one more question. You said that the only way to go after this property, and speaking of the homestead, is to implead in the new wife and institute proceeding supplementary. Since the money judgment was recorded in the county where the property is prior to the transfer as tenancy by the entirety, wouldn't the money judgment trump that transfer anyways? It's recorded, isn't it a superior interest in that?
Well, we wouldn't be able to go after the property without undoing the transfer. So there's a deed recorded in the public records that transferred the property from Robert Spector to Robert Spector and the appellee. The only way to levy on that property would be through the contempt powers of the court, because in a regular creditor-debtor situation, you're not permitted to levy on a homestead property. But under the contempt powers of the court, you would be. But the first step would be to reverse it.
Your lien as a creditor is superior to her interest as a homestead, or is it not? I mean, because I think our case law says that if a money judgment that's recorded in the county does not trump a homestead unless it's recorded prior to the creation of the homestead.
Well, the homestead was already
Or homestead, or is there no?
Robert Spector's homestead was established at the time he purchased the home. So under general creditor-debtor principles, the judgment, you would not be able to levy on someone's homestead with a simple judgment that was recorded.
Correct, but he's already a party.
Correct, but it would only be in the contempt setting that a court would be permitted to do that. It wouldn't be under a general levy principles.
And that's what Meyer versus Faust said, yes?
Meyer versus Faust said you would have to bring in the spouse under a proceeding supplementary in order to undo the transfer or to levy on the property. Thank you, Your Honor.
Thank you.
May it please the court, sir. My name is Craig Weiss, and I represent the appellee in this case, who is Ellen Spector, who was the impled party here. And Judge, I think that it's very important that the timeline here factually be established, because from a factual perspective, this case is different than every other case that is cited by the appellant in its, not only its initial brief, but also its reply brief. And the most important factor is a question that Your Honor asked, which is, this isn't a contempt hearing. This was never a contempt hearing. This was a run-of-the-mill collection action based upon two judgments that were awarded in 2013 against a third party, who is my client. Now, Judge, these individuals were divorced in 1996.
How much alimony has your client paid?
About over $100,000.
And how much should he have paid?
He, I believe, should have paid about $500,000, if not more.
Has he done any time in jail, just out of interest?
Not that I'm aware of.
Okay, the question then is like, what Mr. Lang is saying is that in order to really make the contempt proceeding meaningful, and really we've got a lot of cases, Gepfridge, this is, your client's not in a great position. They need to be able to set aside through proceeding supplementary the transfer to the spouse so that a contempt proceeding against the husband would be meaningful. I mean, how do you respond to that?
Well, the problem is that he purchased this property, the new property. Now, keep in mind, the property that we're talking about here was never the marital property of Mrs. Spector, of Renee Spector, which is different than all the other cases where it was marital property in the marital world. This was a separate property that was purchased not with marital money, with separate money, was purchased 2 years after the divorce and before he was in contempt. This was purchased in July 20th, 1998. That's significant. The property immediately became his homestead in 1998. He transfers the property after he gets married. Now, this is his homestead property now, from 1998 until 2004. Where he gets married, and in April of 2004, he transfers the property to his new wife. In 2013, which is after the marriage and after the transfer by quitclaim deed, July 22nd, 2013, the judgments are entered in the amount of $236,000 and $426,000 plus the interest. So his homestead is established in 1998. It's already his homestead. He then transfers after marriage to the third party. Therefore, in the contempt hearings, it was already his homestead and it was already not an asset.
The question really is a big, it's almost a policy question. Beginning in 1884, when the Supreme Court of Florida decided Carter's Administrator versus Carter, the reason for homestead has been recognized to be sort of a safety net for the family. And the question really is, you're drawing a distinction and saying, well, this wasn't this wasn't money from the marriage. You can sort of separate the money. It doesn't trace out. This wasn't the marital home. And I understand what you're saying, but why shouldn't in the long line of cases where courts have said that homestead should not be used to frustrate the very reason that the homestead exists, why shouldn't that apply at this case? I mean, why should this artificial line that you want to draw protect this person who hasn't lived up to the obligations that he was required to live up to?
Well, I would draw the distinction in this way, Your Honor. First of all, although the case law does say that the homestead laws are there to protect the family, keep in mind that the homestead law also protects the family of Robert Spector and his new wife, my client, who is an innocent third party to all of this, who now has homestead that the appellant is asking be transferred back to Mrs.
Well, is there a principle that in family law that says that a person who marries someone with eyes wide open and knows the existence of previous obligations is on equal footing to that former spouse when it comes to contempt and
Not
so forth?
that I'm aware of. I think that what they are asking for is not only an expansion of the case law that has already been previously cited, but they're also asking for an expansion of the Florida Constitution, which specifically enumerates very limited exceptions to the homestead laws. And what they're now asking for is that no matter the timeline, no matter how long it has been, it could be, such as this case, 5 years, 10 years, 20 years, 40 years, if a spouse who was divorced so many years ago gets remarried, you're now putting the obligation on the new wife to ask the question, hey, before we buy this house, are there any other obligations that you may have so that when I move into my home...
Well, since the judgments were recorded before the house was transferred to her, I assume I'm looking at it, the recording date from Broward County, and it shows the date 2002.
The judgments were actually recorded in, I believe, 2014.
Let's just assume, because I'm looking at a judgment recorded according to the Broward County clerk that was recorded on March 26, 2002. So let's just assume that does exist. Isn't she on notice just like everyone else that purchases a property in Broward County that there's a judgment?
Well,
So just hypothetically assume that there is something recorded.
if there was something recorded prior, then I mean, if it's recorded in the public records, then she is, as with everybody else, certainly on notice that there is a money judgment out there. But I do beg to differ that they were recorded at that time.
Well, I just suggest that you look at pages 1432 and 1449 in the record.
Okay.
Let me ask you this, though. I mean, I hear what you're saying when you throw out, well, what if it's 2 years or 5 years or 20 years or 4 years? But I guess the question that we're grappling with up here, as Judge Gross characterized it, perhaps as a policy decision, I mean, what if, hypothetically, what if the transfer and change of ownership of the former husband's home and insurance policy was done with the specific intent to preclude the former wife from attachment and execution, and all done in conjunction with the former husband's specific intent to avoid support obligations? I mean, what if? What is your position? And it may be the valid legal position. Is your position, sorry, it doesn't make him if it's 1 day or 40 years, that intent is irrelevant?
The short answer is yes. That makes it irrelevant. And there is precedent that I've cited in my answer brief to that very conclusion. And the reason is because despite, and I've cited to some more horrific in factual pattern than this, where there have been, horrible things done by both spouses. The court cannot legislate from the bench. And the Florida Constitution, under its homestead, Article 10, Section 4, enumerates only limited exceptions to the homestead laws. And since this was Mr. Spector's homestead, and this is just a simple collection action of a money debt, it was never an asset that could be transferred back, and it is not one, what egregious acts, as Your Honor has stated, are not one of the enumerated exceptions to the homestead laws under Article 10, Section 4.
And
Let me ask one quick question. In Gepfrich, which is at 582 Southern 2nd, 743 on page 743 of the opinion, it seems pretty clear to me. It says it involved the husband's newly homesteaded home. And Judge Gunther wrote that this home, titled in Thomas's name only, was purchased subsequent to the dissolution of his marriage to Marjorie. It seems to me that that Gepfrich is totally contrary to the position that you took at the beginning of your argument, where you say that this is different than all the other cases that Mr. Lang relies on. It seems Gepfrich is hard for you to get around, is it not?
Well, I would say that out of all the cases that they've cited, Gephardt probably comes the closest to their argument. The difference, though, is that what the court is faced with here today is not what Gephardt is asking for. What the court is what the appellant is asking this court to do is to reverse an order that denied that denied my client to be impled into their action. And my client had the homestead property whose interests are protected. In Gephardt, you were talking about the former spouse's homestead property, and it's factually different than what we're talking about here today, and that may have not have been artfully said.
The insurance policy.
Yes.
We've gone through, that's not the same policy that was required by
That's
the divorce
correct.
judgment, and this was never a policy that the court ordered
That's correct.
anything be done with, correct?
That's correct. With that, and again, we're talking about what they're asking this court to do is expand the law. They're also asking for this court to not expand, but basically eradicate 222.14, which never would have made this in policy an asset which could have been fraudulently transferred in any way, which is exactly what the lower court found. With regards to the insurance policy, we think that not only is it a different policy than what was awarded, but it also was protected under Florida statutes.
And just going back to my procedural question from earlier, I mean, the final order calls your client the impled third party, or the impleaded third party. Previously, the court entered an order finding sufficient proceeding supplementary, and then this order states that the proceeding supplementary is denied. Do you consider that procedurally a ruling on the merits of their motion, or is this a procedural matter denying a proceeding supplementary?
I think that if it's possible to be both, I think that it's actually both, because I believe that in the order it does make factual determinations that because the homestead property and because the insurance policy were never assets, that regardless of the badges of fraud, there could never have been fraud in which to unwind the transfers of those properties. So I think that from a procedurally and factually, the order is sufficient. Thank you, Your Honors.
Thank you.
To address the procedural issue again, the proceeding supplementary was actually granted. There was a motion to dismiss filed on the legal issue, which was denied. There was a motion for summary judgment filed by the appellee, which was denied. We then had a trial and presented evidence, witnesses. All of the issues were presented at a trial, and then for some reason the trial court made a ruling that he could have just made at the motion to dismiss because he made it on a limited legal issue, which the appellee continues to argue and cite case law that has nothing to do with the contempt powers of the court in a familial support case. That's what this is limited to. You only have, in a contempt case, under the familial, if it is support, and it's only related to support, it can't be related to equitable distribution, it can't be related to a general creditor-debtor relationship. There's a case that they cited where a husband poured acid on and shot his wife. It's egregious, but that's not a support case. The contempt powers of the court to levy on homestead property, to levy to get rid of the exemptions under 222 is only relevant in a support case under the contempt powers of the court. And if you obviate that, that will open the door to allow a obligor of a support obligation to simply get married and put all his money into his house and say, not touchable and I'm just going to put all my money into exempt assets, and then you're not able to touch it. In order to avoid that, the Gephardt case, the Partridge case, the Siegel case, and long-standing case law in Florida statutes and the family law rules of procedure allow, simply for in the narrow issue of support issues, allow the contempt powers of the court to look to all assets. It's incredibly clear, and the Gephardt case specifically says The court found it incomprehensible that Thomas could support his lady friend, who made no meaningful contribution to the support and maintenance of his expensive and luxurious home, but could not support his former spouse. That is what we have here. There's not one iota of evidence on the record that in the trial, with the former husband, Robert Spector, testifying, and the appellee in this case, Ellen Spector, testifying, that she put any money into this house or that she put any money into the insurance policy. To the contrary, what the evidence reflected was that Robert Spector is an attorney. He fired his secretary and hired his new wife and paid her the same amount of money that he was supposed to pay my client, Renee Spector, for support. He paid to what was now his secretary, who's the appellee in this case. All the badges of fraud are very clear on the record, and they did not argue one thing against that because there's nothing for them to say. The simple fact of the matter is the case law in Florida, and as Your Honor, Judge Gross recited in the Siegel case very eloquently, flies in the face of what the trial court did in this case, and it's simply an error of law. And because of that, we'd ask for it to be
The
reversed.
Siegel case involved an IRA account, right?
The Siegel case invited
An IRA account, right?
correct, but it talks about the exemptions in general being
I mean,
defeated.
but it didn't really rule on section 222.14. I mean, it didn't involve that, did it?
It didn't involve the specific insurance policy, but the language in there is that those exemptions are not applicable. And the Gepridge case and the Partridge case both talk about how the contempt powers of the court are very broad and the general exemptions are not applicable.
Okay.
Thank you, Your Honor.
Okay, thank you, gentlemen. All right, well.